The following is a local resident producers program. The program content is the sole responsibility of the producer and does not necessarily reflect the views or policies of CATV2, Oshkosh Community Access Television, the City of Oshkosh, the Oshkosh Cable Television Advisory Commission, or Time Warner Cable.
And welcome to another edition of Eye on Oshkosh. I'm Cheryl Hentz, along with my co-host Tony Palmieri. On this edition, we are very, very pleased to be joined by two folks who are running, the only two candidates actually, who are running for the judgeship in Branch 4 of the Winnebago County Courthouse. To my left is Karen Seifert, and she is currently a court commissioner in Winnebago County, has been there for a number of years in that position, and she'll talk a little bit about her work. And then to her left is our current district attorney in Winnebago County, Bill Lennon. So thank you both for being here. We appreciate it, and we know your schedule's busy, and the last time that you folks were going to be on, well, actually when you were going to be on, we had a bad snowstorm. They were predicting a bad snowstorm for tonight, so fortunately that didn't happen. So, but thanks again to both of you.
Thank you for having me.
How do you both feel? You know, congratulations making it through the primary. How do you both feel about how things went, and what are you projecting for the next few weeks?
Well, from my perspective, it's a very busy time. We've got an election on April 4th, and so lots to do, lots of places to go, lots of people to contact, and something just about every night and every lunch too.
Okay.
Bill,
we have remarkably different feelings about how the primary went. Karen ran a wonderful campaign and did marvelously. I need to work harder and focus message better, and that's what we've spent our time doing these last couple of weeks. And the final weeks coming into the election, we're going to really try and focus our message and really deliver a notion as to why they should vote for Bill Lennon.
Okay, well, why don't we talk about that? Why are each of you seeking a position in Branch 4, and what uniquely qualifies you to be judge in that branch? Why don't we start with Bill this time?
I've wanted to be a judge since I was a little boy, out on the playground and in the neighborhoods. I wasn't the one getting in the fights. I was always the one breaking up the fights and being the mediator, the arbitrator. And frankly, I think it's my nature to want to really calm situations and resolve situations appropriately and fairly. I'm one of the weird kids who went to law school hoping to be a judge someday, and this is an opportunity for me to fulfill that dream. I think as the district attorney, I have proven an ability to reason out hard decisions and appropriately apply the law. I've had death inquests, I've had John Does, I've had murder convictions, murder trials with twists and turns. We've had a whole variety of cases that have really tested me, and I think I've proven to the people that I'm capable of making the tough but fair decisions that an independent-minded judge has to be here in Winnebago County.
Okay. All right, Karen, what about you?
Well, I've spent part of my law career as a practicing attorney, and in that position you advocate for one side or for the other. As a court commissioner for the last 5 years, I've been making decisions, and that's a totally different situation. You're not advocating for one side or the other. You're listening to both sides, applying the law and making decisions. And having done that for 5 years, I really feel that I can bring those skills to the bench in Branch 4 and make a difference in the lives of people in Winnebago County.
Okay. Go ahead, Tony.
Well, speaking just for me, I find you both very likable. I find you both very competent. And so much of this does become an experience issue. We'll start with you, Bill Lennon. What is it about your past experience that uniquely qualifies you for this judge position?
What uniquely qualifies me is that as a prosecutor, I'm serving a quasi-judicial role. I'm not only an advocate, I'm obligated to bring justice to every decision I make. So when I look at a case, whether it be a murder case or something lesser, I have to review the facts and apply the appropriate law and do justice. What uniquely qualifies me is I have been on the front lines these last 4 years with difficult, high-profile decisions under the microscope, revealing my true nature and my true character and how I reasoned out decisions, how I applied the law. Every decision I've made, I've been open about. We've said exactly what we are deciding, why we're deciding it in an open and fair manner, and that uniquely qualifies me for this job.
Before you answer the question, Karen, what about the argument that as a you've been a prosecutor for a long time, as a judge, you might be even unconsciously leaning toward the prosecution in a judge? You sympathize with them more than the defense.
There is that sense, and I expect that people will be extra hypersensitive to that as I take the bench. I will prove to them that I can be open-minded and fair. Let's not forget that numerous district attorneys, even in this county, have gone on to be fair-minded judges. Judge Carver was the district attorney. Judge Hawley was the district attorney. They haven't had any problem at all being perceived as fair-minded judges when it comes to deciding criminal cases.
All right, Karen, what uniquely qualifies you to be judge?
I would say the length and the breadth of my legal experience. First of all, in the positions that I've held as an attorney, I've handled just about every area of law there is, from bankruptcy, child support, family law, divorce, restraining orders, small claims, termination of parental rights, juvenile court actions, criminal law, worthless checks, preliminary hearings, bond hearings. I've covered just about every area of law. So that's what I would consider the breadth. And then the depth is, for 5 years, I've been a court commissioner and I've made decisions. And, it's one thing to say you make decisions to prosecute or not to prosecute, but that's not deciding a case. I have decided 10,000 matters in the last 5 years. And so I don't have to spool up if I'm elected to the bench. I already have run a courtroom for 5 days a week for the last 5 years. I've presided over, as I said, over 10,000 matters and made a decision. So I understand how to listen to both sides, how to elicit testimony from both of the parties if they're not represented, to pull out the tough questions and then to apply the law.
Do you think Bill Lennon would be a good judge? If he were to get elected, would he be a good judge?
Well,
I'm going to ask him the same question about you.
I would hope whoever gets elected will be a good judge. I think everyone who comes to the bench has more to learn. No one's been a judge before they're elected. And one thing that no one, unless they've been a judge, knows how to do is sentence. So that's something that everybody's going to have to learn. But in addition to that, I would say as a judge, Bill Lennon will have more areas of law that he has not had experience in than I would. But everybody who comes to the bench is going to have to take training in the areas that they're not familiar with and familiarize themselves and learn things after they become a judge.
Do you think Karen would be a good judge? And
Karen Seifert would make a fine judge.
Then why would
I would
you
be proud.
Why would you be a better judge?
I'd be a better judge because I've been on the front lines, under the spotlights, making tough decisions. It's one thing to decide temporary placement. It's one thing to decide a small claims issue. It's another thing to decide how you're going to prosecute a death where there's an Eagle Scout involved and insanity is being claimed. It's one thing to decide a temporary physical custody. It's quite another thing to look at a University of Oshkosh police officer shooting and decide whether it's justified and then decide whether or not criminal charges are appropriate. Those are tough calls under the spotlight, and I've held up to that scrutiny and proven myself to make those tough calls.
Can we just talk about that for a minute?
Sure.
Since you brought it up, because I know for myself, I was very confused by that, because you said in the media that the shooting, in your opinion, was not justified, yet you did not bring criminal charges against that officer. Can you explain the logic behind that decision?
Yeah, the logic behind that decision was dictated by the law. It's important that people understand that deciding whether or not a shooting is justified is a decision for the DA to make based upon what he thinks is justified or unjustified. A decision to criminally prosecute is a remarkably different decision with remarkably different standards. You have to prove, the state has to prove beyond any reasonable doubt, to the satisfaction of 12 unanimous jurors, that the criminal conduct occurred, that this officer engaged in criminally reckless behavior by simply trying to do his duty and fire off this round at that citizen. We're talking about criminally prosecuting, meeting our burden of proof on a shooting that the university officials had ruled themselves as justified. It's a terrible burden and an impossible burden, I ruled, to meet if you have opinions already rendered that the shooting was justified. They not only said it was non-criminal, they said it was justified. We would have never met our burden of proof in proving a crime against that officer.
Shouldn't you have at least tried? And I realize I'm just, you know, I don't have any law experience, but, you know, if you believe in your heart of hearts, I mean, when you take any case to court, you know, you've got a defense attorney feeling quite differently than you or one of your deputies or your assistant DAs. You always have opposing counsel with a completely different view. Shouldn't you have at least tried to pursue that case?
Wonderful question. No, absolutely not. You cannot
it wasn't
pursue...
so wonderful a question then.
You should never pursue a prosecution just because you believe that it happened or you feel like you want to convict this person. You can only proceed if you're satisfied that there is admissible proof beyond a reasonable doubt to satisfy a jury. If you don't have that, you have to say no. I say no to the police officers all the time. We don't have enough here. Oh, Lennon, you're being a wimp. Oh, Lennon, you're being weak. No. You have to stand up and recognize that as the DA, you're the chief law enforcement officer in the county, and the buck stops with the DA. That was the appropriate decision based upon the law. Would I have liked the glory? Sure, but it wasn't appropriate given those circumstances.
Okay, go ahead, Tony.
I want to raise an issue that's come up in Oshkosh. I know you can't talk about how you decide on an issue. I'm sure you've both heard by now about this controversy over whether to put a Christmas box angel statue in Menominee Park, which is a public park. Is that conceivably something that could come before a circuit judge?
I believe conceivably an issue could be raised that a circuit court in Winnebago County would have to hear.
Okay.
I think it would be rare. It strikes me that they're arguing about constitutional issues that probably wouldn't even begin at our level.
Wouldn't begin at your level. Okay. Well, and the question I want to ask about that is, there are some people in the community who are saying the statue should go up because the majority of people would say yes, put it there. If you're a judge, how much role does public opinion play in the way you make a decision?
It should play zero.
It should play zero, but would it play zero?
Well, I think the independence of the judiciary is probably the most important issue out there, particularly in Winnebago County. It's very, very important for the perception of the integrity of the judiciary that we have judges who are independent, that they aren't making decisions based on politics, that they aren't making decisions based on belonging to a religion, that they aren't, you know, making decisions based on their personal finances or who their friends are or who their family is. What a judge decides has to be unrelated to any of that outside information or the press or public opinion.
All right, so if you get elected judge, you're never going to sit there on the bench thinking, I got to come up for re-election in 6 years. How's this going to look?
No.
You won't think that?
No.
Bill Lennon?
Absolutely not.
Public opinion plays no role.
Karen is correct. It plays no role. It cannot play any role. You have to be guided by the admissible facts and the relevant law. And we've shown that as a district attorney. We've made very, very controversial decisions, decisions that we were criticized roundly for in the press, you know, by Cheryl. And that's an opinion that is perfectly valid to have, that the DA is wrong. But the DA can't be swayed by that. The DA has to look at each situation and apply the law, just as the judge is. I have experience in applying the law on unpopular decisions, and I do so as the judge.
But didn't Judge Schmidt, in the Dringoli case in Neenah, he said that you presented a case that was extremely confusing and extremely convoluted. it sounded like he was accusing you of playing politics with this case.
I don't know if he would ever do that. That's not Judge Schmidt's nature. I acknowledged on the record during my argument that it was convoluted and confusing. I argued that the standard of law was something different, that we should be looking at probable cause. But the judge ruled otherwise. And though it was a kick in the gut, I very politely said that we would look at this case, we would file it anew. We'd clean up the case and we'd bring something that the judge or whoever the judge is would be satisfied with. That's what we'll do. We have judges who rule against us every day. That's something that you have to accept. We had a DA in the past who used to publicly criticize judges and their decisions.
Yeah.
I haven't and I won't. I had some decisions that I disagree with, I will disagree with to my dying day. But you don't criticize. You keep your professional nature and you simply say, I'll fix it and we'll move on.
Okay.
Okay. Well, along those same lines, and really, I mean, I don't want you to think I'm picking on you, Bill. We've had our differences in the past, but I think it's a fair question. With the Dringoli case, you said you've cleaned it up now and you're going to refile it. Could it not, I mean, what happened that it was presented in the manner that it was the first time around? Because as a taxpayer, you know, that's kind of a waste of taxpayer dollars, waste of people's time. You know, in addition to the convolution and the confusion, you know, he also said it contained, the criminal complaint contained misrepresentations and omissions. So how is it that now your office is able to clean it up when you could have just maybe done that the first time?
Well, he never identified where the omissions or misrepresentations were. I'm not sure if he didn't mean something a little bit broader. But having said that, what I did in the first complaint is really put in a lot of motive and a lot of history so that the people would understand what had been going on and what the motives were for this officer to act the way he did act. We had a lot of history and background, a lot of things to give maybe an interesting novel, you know, a kick, but probably not appropriate if a judge wanted a clean criminal complaint. So we'll take that out of there and we'll make it work.
You gonna be a Joe Paulus and make a movie out of it?
Well, I don't aspire to be Joe Paulus.
Let's talk about Mr. Paulus for
Yes.
just a little bit. Karen Seifert, I mean, do you think that the county has been cleared of the cloud?
Well, we've all heard whisperings of John Doe hearings, which are supposed to be confidential and secret. I have no such knowledge of them, but if there are such hearings taking place, until they've completed their investigation, until someone decides if there's someone else to charge, the air isn't cleared. And to me, it's a cloud over our whole county. We need to have it cleared up and we need to move on. And my concern is the public's perception that this is a much more widespread thing than just Joe Paulus and his accomplice, until either people are charged or someone makes a decision saying, we've investigated and there isn't anything to charge, we can't move on. So I'm hoping that if that secret hearing is taking place, that it will be over soon and we can move on.
Hindsight being 20/20, do you think the judges in this circuit were responsible during the Paulus years? Should they have been raising more? We know that Judge Hazy raised questions. We know that Judge Hardkey raised questions.
Judge Carver.
Judge Carver, did they do enough, the judges, during those years?
I think they did enough, and I guess I'm very frustrated in that there are a lot of conspiracy theory people out there who think that anyone practicing in the courthouse knew something or should have known something. And if judges sent cases down to the OLR and the OLR didn't find a basis to do anything, how would the mere hint or allegation, you know, that, oh, somebody must know something, the OLR is certainly not going to do anything with that. And so I think sometimes the public perception is not reality. They don't necessarily know what needs to be shown before anyone can find wrongdoing.
Bill Lennon, do you think the judges acted appropriately in those years?
I think the judges acted appropriately. The judges acted as judges should act. They rule on cases and issues that come before them. If they have a concern about a case, they take it to the proper authorities. They did that. It wasn't on the judges. Frankly, it was on Joe Paulus and his cronies. Their behavior is the one that's criminal, and they should be blamed. I don't like the corollary people, the people on the outside like judges, or frankly like district attorneys, being criticized for the behavior of others. Having said that, the first question you asked is, are we ever going to get over this?
Yeah.
And I don't mean to be pessimistic, you two, but I have my doubts that people will ever be 100% satisfied. The federal investigators did a nice job. They brought some charges. They got nearly a 5-year sentence, and yet we were all thinking that it was lacking. It wasn't enough. Now the Attorney General's office has agreed to investigate it. I'm satisfied they're giving it a good effort. I'm satisfied that they're trying to get to the bottom of things. But they are not going to be able to address every rumor. They are not going to be able to address every slight. We have lived with this for 4 years in our office. Every incident of criminal conduct that we've uncovered or that we've suspected, we've sent on down. Every case that was handled poorly on appeal by Joe Paulus, we've looked at and tried to fix to the best of our ability.
Are you saying
and that's still not enough.
Are you saying it's time to let it go?
No, I'm saying that we have to be patient. We have to recognize that the Attorney General's office can only do so much. They can't be miracle workers. They aren't going to make Joe Paulus be a different person. They are just going to be able to bring charges that they can convict him on beyond a reasonable doubt. They aren't going to be able to address all the nasty behavior. They're not going to be able to satisfy all the rumor mongers. I feel for those people. They have a lot of gripes. They have a lot of complaints, many of them worthy. But I just don't think they can expect these criminal prosecutors, whether it be Peg Lautenschlager or Bill Lennon, I don't think they'll be able to satisfy them completely.
Well, Bill, when you ran 4 years ago, you said that one of your goals was to restore confidence in the office and to get things cleaned up. From your own office perspective and your own personal perspective, do you feel that that has been done then? Is that what we're hearing you say?
Oh, absolutely.
Okay.
Absolutely. We have instituted policies to restore trust. We now have written documents that are required to reduce a felony file to a misdemeanor, misdemeanor to an ordinance. We now have district attorneys or assistant district attorneys who have the discretion to negotiate a case the way they see fit. Unless they act inappropriately or unethically or illegally, I'm not going to intercede. That doesn't, not everybody is appreciative of that, but we can't have a district attorney who's giving deals to some friends and not deals to other attorneys who he doesn't like.
Okay.
Those kinds of things have restored confidence. Our effort to restore confidence has included our efforts to hunt down Joe Paulus and the misdeeds that he's done.
Okay.
Every criminal aspect we've forwarded on to the Attorney General's office. As we said years ago we would.
Okay.
The cases that have been poorly or inappropriately prosecuted, we have taken the appropriate action and worked with those appeals attorneys to fix those prosecutions. So we have done exactly what we said we would.
Okay. Some judges have reputations for being harsh sentencers. Others are considered to be more lenient. Where would each of you fall in that realm? Karen, why don't we start with you?
That kind of a question has to be, I guess, explained a little bit, how you answer that. And when you say what kind of how would you sentence, first of all, judges or candidates are very limited in what they can say about that. But what you have to understand is there are different purposes for a sentence to serve. And what you have to look at is what kind of crime you're looking at and what you want to affect by that sentence. Do you want to affect rehabilitating that person? Then maybe you're looking at treatment options for that person and accountability. Are you looking to you know, some heinous, violent crime? Are you looking to protect society and keep that person away from society and deter them from ever doing that again? That's another theory of sentencing. Are you trying to restore justice? Are you trying to give something back to the victim in how you sentence? And you know, is there some component of the sentence that is giving back to the victim, the community, you know, paying restitution, apologizing to the victim? You know, so I think what the best thing I can say about how I would sentence is I would sentence based on what the crime is and looking at what you want to accomplish by that sentence.
Bill, what about you?
I would look at the gravity of the offense, I would look at the character of the defendant, and I'd look at the need to protect the public. I'd look at those three prongs as I applied a sentence. For the non-aggravated, for the non-violent offender, I'd really emphasize treatment, some kind of probation alternatives, so that this person could turn their life around. We protect the public by making sure that that person doesn't repeat their offense. Probation and the treatment that offers really does give a person a sense of hope and does give them at least the opportunity to try to turn it around. Violent offenses, on the other hand, I think we need to be protected from. And those people deserve worthy sentences in incarceration so that we can have a sense of protection.
Okay, sure. And along those same lines, you know, at the beginning of this year, we started a drug court here in Winnebago County. It's kind of gotten off to a slow start, but Bill, I know you're very supportive of this program. Karen, how do you feel about it?
I think it's wonderful. I'm so tickled that Winnebago County is one of the counties doing that. I mean, that's a cutting edge thing in Wisconsin compared to other states who were quicker to jump on that bandwagon. But you know, it's fiscally responsible. It's going to prevent recidivism. We aren't going to have people coming back. You know, if they're successfully completing the drug court program, they're not going to be coming back and going through our prison, you know, time and time again, and you know, committing the same type of related crime, you know, drug or alcohol. And so, you know, it's rehabilitating people, it's keeping people out of our prisons, and it's fiscally responsible because they're paying for it themselves. And because of how intense the program is, it's going to, you know, the court and the probation agents and all the people involved will be on those people so that they don't have as easy of a chance to fail.
Okay. Tony, we're down to about a minute and a half.
Okay.
So.
For most people who go into a courtroom, it's a terrifying experience. How do you, especially if they're a family member of, say, a victim, how do you as a judge plan to make your courtroom the most comfortable place possible for people coming in? Bill?
To give them a sense that I'm listening and being fair, to give them the sense that what they have to say is important, to give them the sense that this is important to me and it's meaningful to me and I'm serious about what they have to say, and I'm going to do everything within my duty to listen and be fair and independently apply the law to your situation. That in itself will have a comforting feeling.
Okay. Karen?
As a court commissioner, I deal with pro se litigants all the time in very emotional cases, and what I attempt to do is explain the procedure to people. If they don't have an attorney there, they're frightened. Number one, it's a very emotional situation, and they don't know court, but they don't know what they're supposed to do when they get there. And there's not an instruction book. So I try and set everything out for people. You're going to speak first, then the other side will speak. You'll be able to ask questions. Why don't you take notes if there's something you think of, because you can't just speak whenever you want to. I'll let you cross-examine when you're finished. You'll each make a closing argument and then I'll decide. But I try and make them aware of how the procedure works so they can feel comfortable.
We're going to give you each a chance to make a very short closing argument right now. Why don't you look right into camera 3 and tell folks in about 15 seconds or so why they should vote for you, Bill, and then you, Kathy, on Tuesday, April 4th.
Karen.
Karen, I'm sorry.
It's okay.
Thank you. I'd appreciate your vote on April 4th. I believe over these years I've proven myself. I am tested, I'm battle tested, and I believe given that I'd be the best candidate for Branch 4, Winnebago County Circuit Court.
On April 4th, I hope you will consider voting for me. I have been a court commissioner for 5 years. I have experience in a broad variety of law and have been making decisions for the people of Winnebago County for the last 5 years, and I hope you'll let me continue to do that from the circuit court bench.
All right. Thanks to both of you very much for being here, and good luck next month.
Wonderful.
Thank you.
Thank you.
It's Karen.
Thank you, Tony.
Wonderful job,
All right. We're going to take a very short break. When we come back, we will be joined by Judge Tom Gritton, who is seeking re-election to Branch 1. We'll be right back.
We just escaped.
I escaped
I escaped.
by foot.
And ran across a border.
I couldn't practice my religion.
I was put to work in forced labor camps.
If I stay in Cambodia, I would have been dead by now.
If you think differently, then you're an enemy.
If you know how to read and write, you're dead. You speak your mind, you're dead.
The only way to express what I wanted to do was to get out.
I got to the country when I was about 14 years old.
I was 20.
I was 24.
I came here with nothing. No money, no English.
America stood for freedom, it stands for freedom, and that's what all my generation, young generation, wanted to be there.
For the first time, I felt like I have a right to be on this earth.
Here, you can do whatever you want to do.
I love my life here. I feel at home.
I'm free to do what I want.
Freedom to me means my life.
How you doing?
Hi.
Hi.
Have a nice day.
You too.
Thanks.
If only child abuse were this easy to recognize. If you even suspect abuse, call 1-800-4-A-CHILD. All calls are anonymous and confidential. Trust your instincts.
Poor nutrition today will increase Sarah's chances of anemia, add to her healthcare costs, sick days, even stunt her ability to learn. And the thing is, Sarah's not even born yet. Get proper nutrition before it's too late. Call or visit WIC. WIC provides nutrition information, healthcare referrals, even food. Your child has you, and you have WIC.
Welcome back to the second half of Eye on Oshkosh. Cheryl Hintz here along with Tony Palmieri, and we're very pleased to be joined now by Judge Tom Gritton. He has been presiding in Branch 1 of the Winnebago County Circuit Court system here for the last 6 years, I guess. You're trying to seek your first re-election into this position. So, you know, congratulations on being a candidate and having made it this far in your term. It's a tough job, we know. Why don't we start by you just telling us and viewers a little bit about who Judge Gritton is, you know, and why you're seeking re-election to the bench.
Okay. Well, I've been an attorney going on 18 years. I was admitted to the bar in 1988. I'm originally from Kimberly. I graduated from Kimberly High School, went to school in Stevens Point, and then went to Hamlin University School of Law. I initially practiced in private practice, where I did a lot of personal injury, municipal type law. Did that for about 2 years and just wasn't getting into the courtroom. And I had an opportunity at that time to join the district attorney's office here in Winnebago County. I was there for 10 years and I was elected judge in 2000 and have been sitting on the bench since that time.
Okay.
My wife, Lori, and I have 2 kids. My daughter, Melissa, just became a freshman this year at Neenah High School, and I have a 13-year-old son. That pretty much covers, I guess, the big items of my life.
Okay. Sure. And we did, just so the audience knows, we did ask Carolyn Carver to be here, and she did agree to come on and then had a scheduling conflict and so could not be here. So anyway, His Honor will have the full 30 minutes by himself.
Well, Judge Gritton, thank you for being here. And the main issue that has been raised by your opponent is this issue of judicial substitutions. Every defendant who comes into court is allowed one substitution request for a judge. Is that right?
That's correct, and they don't need a reason for that.
They don't need a reason. And according to data from January of 2000 until January of 2000, or until December of 2004, you had the top number of substitution requests, 1,025. and the next closest was Barbara Hart Key with 98. That's quite a wide disparity. So how do you explain that?
It is a wide disparity. I think what people need to keep in mind about when I started on the bench, I came directly out of a district attorney's office. And if you look at some of the newer judges that came on, let's talk about Judge Key and Judge Wolt. Judge Wolt came out of private practice, was doing some criminal defense, not a lot, but mostly he was doing workers' compensation type things. Judge Key actually came from the court commissioner's office, and then before that she was a public defender, but before that she was in the district attorney's office. So people didn't have that memory of her necessarily as a prosecutor. And I think it's important for people also to understand that these people coming through the system, we don't get a lot of new people. Most of the people that come through the system are recycling. And so what happens is all of the people in the 10 years that I've been involved with prosecuting, when they come through the system, if I'm the judge that they appear before, literally in July I was prosecuting people. On August 1st of 2000 I took the bench, and all of a sudden they see me as the judge and not the prosecutor. And there's a perception, I don't, you know, people believe, some people believe it's true, some people don't, that I tend to be on the tougher side. And having come from the district attorney's office, there are people that I prosecuted. They know I was a zealous prosecutor, and their wish is not to be necessarily in front of me. I also know that as a result of I do a lot of probation and supervision reviews. I monitor people who I place on probation very closely, and I know the defense attorneys have told me right out that if they have clients that they don't believe are going to be successful on probation, they don't want them coming back once a month or once every other month for me to monitor their behavior, because they know they're going to be unsuccessful. And that's another reason that they get out. But I think probably the most important thing to keep in mind, and I brought information from our circuit court administrator. I know my opponent is saying that the numbers are creating other workload issues for judges, and that's just not true. And I'll just show you some representative numbers. The year is from 2004, and these are cases that are disposed of by the circuit courts in our county. And I'll just quickly run through the numbers. Disposed of cases in my branch in 2004 was 1,726. If we move to branch 2, disposed of cases is 1,603. If we move to branch 3, now Judge Key is our probate judge, so she signs off on all probate cases, which is a little different than, we all have a specialty. I'm in charge of civil, Judge Wolt is in charge of family, Judge Key happens to be the probate, so she signs off on a lot of things that come through the probate office. And if you matched up her probate numbers, say with Judge Wolt here, Judge Wolt had 84 probate cases, which is pretty consistent across the board, while Judge Key had over 900. And because of her specialty. So if we take that number off, she's around 1,850, 1,860, somewhere there.
But this is just the year 2004 you're looking at?
Yeah.
Okay.
But the numbers are consistent, and if anybody doubts those, they can get a hold of Jerry Lang. And Jerry Lang, our court administrator, will tell people that the dispositions have been consistent among the 6 branches.
I think the reasons that you've given for that disparity in substitutions make a lot of sense. Except for the fact that the disparity is very, very large. I mean, if it was 1,025 for you and the next closest was 500, but the next closest is 98.
Well,
doesn't that seem like not just that you were a prosecutor and tough, that you were associated with Mr. Paulus?
I don't think it has anything to do with the fact that I worked for Joe Paulus. In fact, I think if you look at the people who are endorsing my candidacy, I have over 50 lawyers, many of whom are criminal defense attorneys. All of those people have a confidence in me, otherwise they wouldn't be endorsing my candidacy. I think the other thing that you also need to look at is, as we've gone now this past year, has been my lowest number of substitutions, and I think it was 100.
What changed?
I just think people have, when you get further and further away from being that person coming out of the DA's office, I think I don't have as many people that I prosecuted, because they're, you know, as people get older, 25, 30, they kind of figure it out that either they're going to be in the system for the rest of their lives or something clicks.
So you haven't become more lenient?
No, I don't think that's true at all. You know, and I'll say this. I think it's important too is obviously I've matured over the years, and I would hope that that's true with whether it's, you know, my first 6 years, my second 6 years.
Sure.
And I've matured over the years, and I think that people have a confidence that they can expect certain things depending on the type of situation. Not that every case is individual, but I think ultimately the endorsements I've gotten from the attorneys is a ratification of the fact that I'm doing a good job.
All right, sure.
Yeah. Well, you know, Joe Paulus's name has come up, and certainly this wouldn't be a complete interview if we didn't talk about that correlation there. You did work in his office, you said, for 10 years. That was all under him. You were at one point his deputy DA. You know, the argument has been made out there, and right or wrong, it's been made, and by myself included, that how could Tom Gritton, not then a judge, but how could Tom Gritton, the deputy DA, assistant DA at one point, how could you work in that office for 10 years and not hear or see that something was amiss somewhere, and yet two young guys like E.J. Jelinski and Tom Chalkoff are there a very short period of time, and they sense something. How would you respond to that?
Well, I think it's important to know how all of that came about. There was information of money being exchanged brought to those gentlemen. And they did exactly the right thing, reported it, and it got investigated, and at that point, obviously, the rest is history. What I can say about my time in the district attorney's office, and if you look at the way that Mr. Paulus and Mr. Sherlin were doing this, and looking at those individuals, I mean, my understanding is that they were putting money in a sandbox outside of Mr. Sherlin's home.
And under a rock.
Yeah, and so it wasn't something that was happening in front of everybody and their uncle. You know, for those of you that know Joe Paulus, he's not a stupid man, and he clearly has been involved in the system for years. And if anybody's going to be able to hide criminal behavior, it would be an individual such as Joe. And I find it interesting that people believe there's this huge conspiracy because, you know, there's been an ongoing investigation in this area for, what, 4 or 5 years. And there's never ever been a legitimate investigation that's pointed the finger anywhere other than Mr. Paulus and Mr. Sherlin. And if there was truly this big conspiracy going on, let's be serious, somebody else would have had the finger pointed at them with facts, not just innuendo, but facts. And I look back at my time in the district attorney's office. I'm proud of the service I did to the county, or for the county there, and for the state of Wisconsin. There's a lot of good people that worked in that office that have been stained by Joe Paulus, and it's unfair. You know, and there's still people that worked under Joe Paulus that are working with our current district attorney. And so I think when you sit back and you look at it, and I think what it's been is it's been kept alive by a small group of people because they want to be able to use that as time goes on.
But does it bother you, Judge Gritton, when people like a client of an attorney, Richard Bolenbeck from Appleton, who his name has been mentioned in some of these issues, but his client named Melinda Otto, this was quoted in the Appleton Post-Crescent, she alleges Bolenbeck promised her a lenient sentence based on his ties to Paulus and Winnebago County Circuit Judge Tom Gritton, who presided over her case.
Do you know what the sentence was in that case, Tony?
No.
I went above the district attorney's recommendation. I sent her to prison because I thought that was the right thing to do. So if he had such ties with me, I guess what I would say is she'd have been on the other end of the spectrum. Does it bother me?
Yeah.
I mean, day to day it bothers me that people make accusations about me. I mean, I know what I've done. I know the type of person that I am, and it bothers me that it's got to.
Right.
You know, and I think that our county, it's been incredibly difficult on everybody in this county.
Sure.
And it's been incredibly difficult with the people that have worked for him. And down the line, whether it's staff who worked with him or lawyers who have worked with him, you know, and ultimately what it comes down to is, bottom line, I can go home at the end of the day, know exactly what I've done as a prosecutor and as a judge, and know that I've done the right thing every time. And that right thing, to me, is I know I did it.
Okay.
And so that to me is the most important thing.
Do you think that the Office of Lawyer Regulation failed through that whole process? And do you think that OLR, does that need to be reformed?
OLR is not set up to be a criminal investigative type tool. They deal with specific types of complaints. And I don't know, a lot of what they did or didn't do.
Right.
But one thing I want to add on to this, I think it's also interesting that there are some of the people who were initially involved in this whole Paulus investigation and the finding out about this who are endorsing my candidacy. Ann Gallner, police officer from the city of Menasha, is endorsing my candidacy. Tom Chalkoff is endorsing my candidacy. Retired Judge Robert Haase, who was involved in the middle of some of this, they're all endorsing my candidacy because they believe in me, in what I've done as a judge, what I've done as a lawyer, and what I've done as a prosecutor.
Okay.
Okay.
But do you think that the Office of Lawyer Regulation needs reform? Is that something that judges should come out and obviously, judges have to have trust in the attorneys before them, right?
Absolutely.
And if the attorneys are not acting ethically, we need to have some strong mechanism in the state, right?
Well, I think one of the things that doesn't happen enough is when lawyers do things that are wrong, they don't get hit hard enough.
Okay.
I'll say that. But I just haven't had enough contact with the Office of Lawyer Regulation to know procedurally, exactly how they work. I mean, I know where to refer people if that's an I've had to do that as a judge. I've had to refer people, lawyers as a judge, and so I understand the referral process. But the nuts and bolts of how OLR works, I guess I'm not enough of an expert to be able to make that
I guess
answer.
because the feeling I'm getting, Judge Gritton, is that, and this really is less about your candidacy, just as a citizen, I'm not convinced that what happened with Mr. Paulus couldn't happen again in this county.
Well, you're exactly right. And the reason I say that, and I agree with you, is because I ask questions. I had a case today where I was concerned about the resolution. Not because I think either one of the lawyers or anybody was doing anything wrong, but I ask questions. And when I ask questions, I expect exactly what you said.
Okay.
When they come before me, I expect candor from them. If they tell me something, how do I say, I don't believe you. So our system is based upon an incredible amount of trust, and that's why I go back to saying, when that doesn't happen, there needs to be serious repercussions for the attorneys.
All right.
Okay.
I agree with that, yeah.
Let's talk about experience. I mean, you've given us a rather brief background of your history in law and the legal profession. Carolyn Carver, on the other hand, her father has been a judge in this county for as long as I can remember. She's made at least 2 attempts at district attorney.
Not one.
I thought it was 2. I thought she ran twice.
Just once. When Mr. Lennon ran against Mr. Paulus back 93 or 94.
Okay. I thought, for some reason, I thought she had made a second attempt at that. But in any event, that failed. Now she is running for judge. And unfortunately, she can't be here to talk about her qualifications. But what are your qualifications that set you aside from your opponent? And why should people re-elect you? What uniquely qualifies you?
Well, the thing that happens in the age that we live in today with technology is that you can have people go and check what we've done. And I've done that. During the time that I've been a judge, now this is from August 1st of 2000, I've handled over 8,000 cases. I've been the responsible person for 8,000 cases, over 8,000. When I did that same check on my attorney, or on my opponent, she has handled 19 cases as a responsible attorney. Which means there are cases where she's the attorney of record. 18 of those 19 cases are collection actions on behalf of the company that her husband is the general manager of, and the other is a divorce.
18 out of the 19?
Yes.
Wow.
And that goes back to 1999, not 2000. I have, as a judge, I don't have the exact number because it changes. I mean, we've been trying a lot of cases for whatever reason lately. But I've handled approximately 60 cases to jury in front of juries as a judge, and before that I handled about 70 cases in the district attorney's office as an attorney in jury trial. So I have about 130 in that ballpark. My opponent has 2 in the time that she's been in private practice that I'm aware of. She's had none over the last 7 years. And the type of judge that we're the day-to-day working of the criminal justice system and the civil justice system. And to be qualified, you have to be able to deal with multiple types of cases. You need to large volume of cases. Probably one of the biggest surprises that I found out as a judge is the administration of the courtroom and the court process takes a lot of my time. But I'll say this, probably about 75% of my time has a prosecutor involved in the case. Civil cases we do not really spend a lot of time with, because what happens is you schedule things with the attorneys, and for the most part those cases, the way with mediation has gone now, those cases resolve themselves. I think I probably had, out of that 60, 10 to 15 of the jury trials have been civil in nature. Family law cases, we don't spend a lot of time because, again, they're mediating family law cases and they really want the families to make the decisions rather than the judges. So I would say probably 70, 75% of my time is spent dealing with whether it's a city municipal citation, a criminal case. Right now I have 5 homicide cases pending in front of me. You know, so you need to be able to deal with the large volumes. You need to be able to have the experience of dealing with those cases day to day, and that's what I've done for the last 16 years. Whether it was in the district attorney's office or as a judge now, I've been doing it every day for the last 16 years.
You said, Judge Gritton, that you've gotten quite a bit of endorsement from attorneys.
Yes.
Why are they endorsing you in your judgment?
I think that the reason they're endorsing me is because they believe that I'm doing a good job. And I know early on, because of my background coming from the criminal standpoint, I know that some of the civil attorneys, and probably more so the family attorneys, were a little concerned that I hadn't practiced in that area. I actually had to some extent when I was in private practice, but it had been a long time. And as a result of that, I knew that going in, so I spent a lot of time. The lawyers in our county are excellent from the standpoint of being willing to assist. And you know, some of my biggest supporters now are people who do strictly family law.
Well, how do you assure, see, I think for a lot of people on the street level, when they hear judge endorsed by lawyers, they're thinking, are those lawyers looking for favorable treatment? How do you assure the voters that in return for these legal endorsements, you're not giving them favorable treatment in the courtroom?
Well, to believe that that happens, I mean, I think that's a cynical way to look at it, Tony.
But you know, we're in a cynical society, you would agree.
Yeah. Well, the endorsements ultimately, most lawyers, and I know that this is hard for people to believe, we have a professional life and we have a personal life. And those two are very easy to distinguish. And I learned the hard way as I was a very young lawyer because I got too personally involved in things. And when you look professionally, one of the things that happens when you become a judge is you become very isolated. That was a surprise to me, how isolated I became as a judge. Lawyers have the expectation that they're to be treated fairly. They don't expect every time that you come before them that you're going to decide their way. It doesn't happen.
Right.
I can tell you it doesn't happen. I've been in that situation. But I think lawyers, on the same hand, want somebody, and this is the type of judge that I think I am. I think they want somebody that's going to listen to their argument. I think they want somebody that's going to look at the documentation that they provide. I think they want somebody that's going to look at the law and then make a decision. I'll tell you right out, because I'm a human being, I've not been right every time. And I've been down the road and you know, I've been appealed. I think I've only been overturned twice, and one of them is still pending in the Supreme Court of the, for the state. And so I don't think the public needs to be concerned at all about those. Every judicial race we have, lawyers want the people, I believe, that they think do the best job. and do it for the right reasons.
Okay, sure.
How do you feel about, you know, we just had Kathy Seifert on and Karen Seifert. I keep doing that. I don't know why. We just had Karen Seifert on and Bill Lennon, who are running for another branch. And we talked with them a little bit about the drug court program. Now, I realize that this is mostly two other judges, you know, Judge Wolt and Judge Key, but, you know, certainly you are aware of it. How do you feel about that program and other similar programs?
Well, I think it's a good idea. I mean, the reality of our situation is with the way our society is going today, from a financial standpoint in government, we have to find better alternatives. Better alternatives aren't incarceration. Now, I'll say this, though. There are people who need to be incarcerated. And as a judge, you have to be able to pick the people out that need to be incarcerated, and you need to be able to pick the other people who you can work with. I'm a huge advocate, and I've been involved in several programs and initiated some of those programs to be able to do some of those alternatives. I think the time that Judge Key and Judge Wolt have spent putting that program together is incredible. And I think down the road, it's only going to pay big dividends. The reality is, and I say this all the time, is if it wasn't for drugs and alcohol, I'd be out of a job. And so, and there's a third factor there. We need to change the way people think. And the cognitive thinking is something that I think we need to take a better look at, because unless we change the way people think about what their behavior is and the way that they treat other people, we're not going to change people's behaviors. And one of the reasons I really believe this, we started a program called Drunk Driving Victim Impact Panel. And we have a speaker that talks every time who's an offender. And the people from the Drug Abuse Correctional Facility come over and they bring their people and they listen to these speakers as well. And I had the opportunity one night to sit down for about a half hour and talk to these offenders. And they're convinced that the program that they're taking part of in the prison system is the best program they've ever had, because it's changed the way they think about things. And I want to think of a way to do that whether it's out of the prison system. You know, maybe it's a jail setting, because we haven't gotten that way, but it costs money.
Sure.
And we have to convince the people with the purse that this is a better way to do it than spending more on building a bigger jail.
Okay.
So, but those two are not necessarily the same. I want to make that very clear.
Okay.
There are people who just can't live by the rules and need to be removed, and then there are people you can work with.
Okay.
Just one last question, I guess, on courthouse security. Are we okay on courthouse security? What needs to be done?
Well, realistically, I think that our courthouse is antiquated. I think that it's very difficult. And I think one of the things people forget is we have an obligation as employers to protect our employees.
Absolutely.
And I think we've kind of reached a happy medium. What we're doing now, I'm the head of the courthouse security thing. The state Supreme Court requires every county, the judiciary, somebody to be involved in that. And we've been slowly each year improving the way things are in our county, whether it's the way a thing is built in the clerk of court's office or the family court. And we made priorities. Family court was the #1 priority because of the nature of the things that go on there.
Okay.
But as a judge, I face everybody, you know, so I can see everything happening. So from my standpoint, I'm probably the safest person in the courtroom.
Okay.
All right. Why don't you take about 20 seconds or so, Your Honor, and look into camera 3. Tell folks why they should vote for you on Tuesday, April 4th. This election comes down to really one thing. It comes down to experience. The experience that I've had over the last 16 years, both as an attorney and as a judge over the last 6 years, is the difference. Bottom line is you need somebody in these positions that has the experience, the temperament to be able to function on a day-to-day basis with large volumes of cases and with the experience necessary to be able to handle those cases. And I have no doubt in my mind that that is me. And I would appreciate your vote on April 4th. Thank you. All right, very good. Thanks very much for being here. We appreciate it, and best of luck to you. Tony, thanks to you, and as always, thanks to you for allowing us into your home for the last hour. We'll see you next time. Until then, take good care and keep your eye on us. We've got our eye on Oshkosh.